Hi, this is Brian Ka with another video to help you pass the California Baby Bar and the Bar exam. So we're going to do another Wills and Trusts essay, and this is from July 2012, question 5. So let's read the call of the question and see what we have to discuss. So here, the call of the question says, what rights, if any, do Dot and Sam have in May's estate? So we have Dot and Sam. We're trying to figure out what rights they have in May's estate. That's all we know. We don't know anything about this fact pattern other than simply Dot, Sam, May. We have three individuals, and I don't really know what their relationship is, but we do know that Dot and Sam are we're trying to figure out what they can get, what rights they have in May's estate. So, question 5, the fact pattern goes, in 2004, May, a widow, executed a valid will, intentionally leaving out her daughter Dot and giving 50% of her estate to her son, Sam, and 50% to church. Okay, so her will is what? Intentionally, right? Left out Dot. Here's Dot. And left 50% to Sam and 50% to church. That's what May's will had at the time she executed her will. Okay, so in 2008, after a serious disagreement with Sam, May announced that she was revoking her will and then tore it in half in the presence of both Sam and Dot. Okay, so we got a trigger word here, and that is revoking, right? And we know that revocation is a huge subject or theme that the bar graders love to test. So I will talk about first whether this revocation was valid to begin with. The reason why I wouldn't start with whether there was a valid will and go through the elements is because here it says, may a widow executed a valid will. So if they're telling us that this will was valid, I don't think that there is a need to go further into whether this will was valid, right? But we do have to go through whether this revocation was a valid revocation. And in order for us to figure this out, we're going to have to work with two elements. And the first one is if there was an intent to revoke the will, right? Second, it's got to be followed with a physical act. And these physical acts could be anything from tearing up, burning, destroying, obliterating. Basically, they're all similar words, but I like to use all these just to show the bar grader what it really takes to revoke a will. And it's not a one-part test, it's a two-part test. And we have to use the facts to prove that there was an intent to revoke, plus a physical act followed by this intent. So I would use, because the fact pattern here is not that long, all we get here is the fact that that May had a serious disagreement with Sam. So I'm gonna write May and Sam fought. But what I really mean by fought is that they had a disagreement, right? And after that disagreement, there was uh, May tore the will in half, right? So this is definitely satisfying. Now, when you get into a disagreement and when you tear something up, that is, basically showing that May did intend to revoke this will. Because after a disagreement, or if this was, let's say, they had a happy dinner or lunch, and that all of a sudden, if May decided to tear up that will, then that's a little bit iffy as to whether there was an intent to revoke. But the fact, all we're given is that they got into a disagreement shows that most likely that she had the intent to revoke the will. So I would say that the first part test, intent test, is satisfied. And physical act, the facts told us directly that she tore up the will. So does this pass the two-part revocation test? Yes, it does. So conclusion is yes, the will was revoked. And now that the will is revoked, what happens? May is left without a will, right? Because she revoked the only will that she had by um, satisfying these elements. And because she satisfied these elements, there was a valid revocation, and May ended up without a will. So let's talk about or read the second paragraph. In 2008, after a serious disagreement with Sam, okay, we already read that. The third paragraph says, in 2010, after repeated requests by Sam, May handwrote and signed a document declaring that she was thereby reviving her will. Okay, so this revocation happened in 2008. Now, in 2010, 2 years later, she wanted to revive her will, and how she did that is she handwrote and signed the document declaring that she was thereby reviving her will. Now, when you see the words handwrote plus sign, that should automatically trigger what is called a holographic will, right? Why should that trigger the holographic will issue? Well, holographic issue will is when a will is um, signed, first of all, signed by the testator. And here it's easily satisfied. The second element is that all the material terms must also be handwritten, right? So this issue as to whether there was a valid holographic will, yes. The number one first test, whether it was signed by the testator, yes. Now, whether all material terms were handwritten, I'm not sure. Let's put a question mark and look at the facts again. So here, she signed the document, okay, and she handwrote, declaring that she was thereby reviving her will. So there was a sign and a clause saying that she was going to revive this will. Now, does reviving the will clause satisfy whether there were all material terms within that handwritten holographic will? Obviously not. You know, it doesn't have, what was included in that will. It doesn't even have which parties are um, included in this will. So obviously, as to whether there was a valid holographic will, it fails the test. So here I would write no holographic will. However, she intended to incorporate by reference the 2004, because this was 2004 will right here, when she intentionally left out dot, 50% to Sam, 50% to church. If she wanted to incorporate uh, by reference this 2004 will into this 2010, then she may have a chance of reviving this will, right? So here, the third issue, I would go into incorporation by reference. And the elements for incorporation by reference is whether this 2004 will existed at the time, right? Did this 2004 will exist when she um, tried to create a holographic will? Yes, it existed, right? Now, does it reference the the 2004 will, right? Now, here she said um, she attached all the torn pages to the will to the document, and she wanted to thereby revive her will, right? So when she talks about reviving her will, she's referring to this 2004 will, right? So yes, it was referenced. So it existed at the time. It was referenced. And third, did she intend to incorporate that will by referencing it, by reference, right? And I guess this is very similar to number two, whether she had the intent to incorporate is proven by her actions, which she attached all of the will, torn pages of the will to the document. So when she uh, reattached all the torn pages of the will to the document, that obviously shows intent to incorporate that 2004 will, right? And the facts told us here that she had all the torn pages and she reattached it. So it existed at the time when she tried to incorporate uh, this will. into 2004, and it did reference it because she wanted to revive the 2004 will. So, although under an ordinary holographic will analysis, she fails because all the material terms were not handwritten in this 2010 holographic will, because this issue of incorporation by reference, and because there are three elements, or it could be four, but as far as I remember now, I'm just going to write three. But if you can, you know, do better than me in memorizing this element, I think you should write four. But in the end, this incorporation by reference will succeed, meaning that this handmade, handwritten holographic will, through incorporation by reference, will be valid, right? So, holographic will becomes valid. So when I say valid, what does that mean? It means this 2004 will becomes revived, meaning this will intentionally left out thought, and 50% goes to Sam, and 50% goes to church, right? And then when you read further down the line, it says when the time she signed this document, she was entirely dependent on Sam for food and shelter and companionship, and had not been allowed by Sam to see or speak to anyone for months. By this time, church had gone out of existence. Okay, so when she signed this will from 2010, right? She had some issues, and the issues were that she was dependent on Sam for food, right? And shelter and companionship. Basically, she couldn't survive without Sam by 2010, right? The will, again, intentionally left out Dot and gave Sam 50% and church 50%. So the issue that comes up here should be whether there was undue influence by Sam, right? And if there was undue influence by Sam, that means that um, since Sam was the um, beneficiary getting 50%, if there was undue influence, then basically that 50% going to church will still stand. But because of undue influence, the other 50% will end up going into intestate share, which means because California utilizes per capita system, and because May doesn't have a spouse, and since both Dot and Sam are alive, it means 50% goes to church, and the other 50% will end up with Sam and Dot, meaning 50% goes to church, 25% Dot, and 25% Sam. But we can't just say whether there was no undue influence or undue influence. So we're going to probably have to talk about, right, undue influence, and it would be up to Sam to prove that presumption that there was undue influence with May and Sam. And there are three types of undue influence that we could talk about. We can talk about case law undue influence. we could talk about. I know that number three is statutory, right? I think it's. Uh, I just had a brain fart, but I know for case law, because this is so much information. For case law, um, let's say this is let's just name it confidential relationship. Case law is when there is a susceptible defendant, right? And plaintiff took advantage of it, and which results in unnatural result. And obviously, this is very arguable. I would argue the heck out of both sides. Obviously, May was susceptible by this time. She was weak. She needed uh, somebody to depend on for food and shelter and companionship. So that was a lot, right? And the fact that this holographic will was going to benefit Sam because it revived his 50% stake. You could argue that that was an unnatural result stemming from what had happened between uh, Sam and May's relationship. Now, Sam is a Sam is May's son, so there is a confidential relationship, right? And Sam took action to take advantage of that relationship, and that could be argued both sides also. Sam could argue that I did what I could as a son. I did everything I could, and there was nothing that I have done wrong. On the other hand, um, May could argue, or the other opposing counsel could argue that you know there was some kind of uh, action by Sam which led to this unnatural result again, thereby uh, making Sam the 50% beneficiary to May's estate. Now, statutory, we have to talk about whether May was also beneficiary, but this won't really apply because May was not the beneficiary; it was Sam and Church. So I would argue, both sides. My senses tell me that there could be undue influence, right? Now, if there is undue influence, um, yes, undue influence, we're going to have to figure out how to dispose of both uh, 50% that was supposed to go to Sam, but now it's going to be under intestate share. And there's another issue with church because here it says that the church had gone out of existence. So that means that to get rid of this church asset, we have to know that this 50% that belonged to church had lapsed because the church doesn't exist anymore, right? And when you talk about lapse, you usually talk about anti-lapse statute for California. And when you talk about anti-lapse statute, it usually talks about the blood relative that gets uh, this 50% instead of lapsing. But here, church is not a person, church doesn't have any blood relatives or issues, which means that in this case, the church 50% will end up going into intestate, right, without a will. So here we have 50% church, now 50% Sam, 50% church. But this is not going to go to church, but it may go to uh, Sam plus dot. Because um, in California, using per capita system, usually it's going to go to the spouse, right? But since May did not have a spouse, the priority that goes to the spouse is no longer valid. So the next line, the issues, the Sam and thought, will share, since they're still alive, get 25% of this 50%, right? Um, so that's that. Church doesn't get anything because it lapsed simply. California statute, anti-lapse statute will not apply because church is not a person, and church didn't leave or can't leave any blood relatives or issues. So instead of going to church's blood issues, it's going to revert back and be taken care of in intestate share. And in California, using per capita system, the first priority goes to the spouse. But since May didn't have a spouse, it's going to go to Sam and Dot, and this 50% will be split one half. And Dot is going to get basically 25% of the whole, and uh, Sam is going to end up getting 75% of the whole. Uh, if, this is if there was no undue influence, right? Now, if there is undue influence, obviously Sam's 50% is, over, and this 50% will be taken care of under intestate share. So um, in that case, Sam gets 25 and Dot also gets 25, right? Now, if there was, assuming that there's no undue influence, and if Sam ends up getting 75 and Dot 25, there is an argument that Dot can make, which is the theory of an omitted child, right? Now, if you want to argue that you're an omitted child to get a bigger piece of the pie from here, she would have to be unknown child at the time the testamentary instrument was created. And there are three exceptions. First one is if she was intentionally left out, right? Now, in this case, Dot was intentionally left out, right? So and May knew of Dot's existence. So under this omitted child doctrine, which thought could attempt to argue this will ultimately fail. So I guess the important thing here is to organize your essay, and do two scenarios after you figure out whether there is undue influence or no undue influence. And depending on that, that decides what portion of this estate that Sam gets. And once we figure that out, we're gonna have to go into the per capita intestate share and divide that into these two children. And if there was an undue influence, then we'd be talking, the split between both Sam and Dot, which would be 50-50. But in this case, if there was no undue influence, then Sam would end up getting 75% of the entire estate, and Dot would get 25% of the entire estate. Now, this was not easy. I would say like this is like a 7.5, maybe an 8. But I think that the main thing that you have to focus on for this essay is to make sure you organize everything correctly, and make sure that if you can, make sure you conclude whether there was undue influence or there wasn't undue influence, because that would change the analysis after, whether Sam receives 75%, or whether this goes May's estate goes under an intestate share, in which Dot will get more of what May's estate had at the time. So with that, I know this was a lot, even for me while doing this. It wasn't easy, but I think this was great practice. If I missed anything, I probably did, because this was one of the most difficult wills and trust essays. Make sure you note it. If you want to comment on it, feel free to do that. I'm not here to be perfect. I'm just here to um, show you what goes into my thinking whenever I'm working on a complicated, wills and trust essay such as this. And by you watching another person go through this difficult question, I'm just hoping that you can get some value out of it. And rather than trying to struggle by yourself, trying to figure out, how did the uh, bar model answer derived at that. Don't do that. But by working on this together, and acknowledging that this is a hard question, and watching somebody struggle through it, I'm just hoping that it'll help you understand this question better and understand these concepts better than before you've watched this video. So with that, I thank you again, and I'll see you in the next video.